Hello, everyone, and thank you so much for attending today's webinar. It's H-1B cap season time, a very timely and important immigration topic during this time each year. Before we begin, we just wanted to cover a few housekeeping items. If you have any questions during the webcast, you can submit them through the Q&A widget at the bottom of your screen. We've carved out plenty of time at the end for questions. We will try to answer all of your questions during the webcast, but if a fuller answer is needed because we're running out of time, we're happy to answer your questions later on via email. Also, a copy of today's slide deck will be available in the resource widget. We encourage you to download any resources or links that you may find useful. You can find additional answers to some common technical issues located in the Help widget at the bottom of your screen. This webinar is CLE accredited in California, Illinois, and Texas for 1 hour of general CLE credit, and in Missouri for 1.2 hours of general CLE credit. Additionally, this webinar is CLE accredited in New York for 1 hour of experienced and transition credit. The webinar is also approved for 1 hour of SHRM and HRCI credit. We award credit based on attendance for the entire 60 minutes. Due to changes in jurisdictional requirements, you will notice that we're no longer using automated pop-up attendance checks. As required, we will display secret words in multiple choice polls during the webinar. You will be required to select today's secret word from a multiple choice list. Please respond to these polls to demonstrate your continued engagement and to earn your full credit. We value your opinions and appreciate your participation in the course. As we begin, we just wanted to provide a quick introduction about us. My name is Fatima Khan, and I'm a partner at Thompson Coburn, where I lead our firm's national immigration practice. I have over 2 decades of immigration experience, primarily focused on business immigration matters. Here at our firm, we have a robust team of immigration professionals, and joining me today is my wonderful senior associate, Melinda Potmesil, who also has many years of business immigration experience. We'll be jointly presenting today's webinar, and we've put together a series of slides to guide you through today's discussion. So what does an H-1B mean? H-1B is defined as professional specialty occupations. Specialty occupations are those, according to the regulations, which require theoretical and practical application of a body of highly specialized knowledge and attainment of a baccalaureate or higher degree, or its equivalent as the minimum requirement for entry into the occupation in the United States. Now, some of the common types of occupations that qualify for H-1B status include, but are not limited to, positions such as software developers, IT professionals, engineers, architects, physicians, and other healthcare workers and researchers. Also, business occupations in finance, supply chain, marketing, procurement, as well as accountants, auditors, teachers, and professors. Again, this list is not exhaustive, but just representative of some of the common types of H-1B occupations.
While H-1B status is specific to the individual, it is considered an employer-sponsored filing for temporary work authorization. By filing the H-1B petition, employers are making certain attestations to the U.S. Immigration Service, specifically that the position they are offering is considered a specialty occupation, that the individual they are hiring meets the academic requirements for the position, and the employer will pay the minimum prevailing wage as set by the Department of Labor. With an approval of H-1B status, the individual is given approval to live and work within the U.S. for a total of 6 years of eligibility. This 6 years of eligibility does attach to the individual. It does not reset if the individual changes employers during that initial 6-year period. Individuals are able to be sponsored for 2 3-year periods of H-1B status. So at the end of the initial 3-year period, if an employer wishes to continue this H-1B sponsorship, they will be required to make an extension filing with the USCIS Immigration to continue that temporary work authorization. The H-1B holder is allowed to also bring family members who qualify for a dependent status. Spouses who are legally married and minor children who are also unmarried under the age of 21 are eligible for what's called H-4 dependent status. This H-4 status is approved for the same period as the H-1B holder, and they are allowed to remain in the U.S. with the H-1B employee as long as that individual is maintaining H-1B status. The initial H-1B approval period is approved by the U.S. Immigration Services, the U.S. Citizenship and Immigration Services, which is called the USCIS. But there are also 2 other government agencies that H-1B workers frequently come in contact with when they were maintaining H-1B status. The initial status for individuals in the U.S. is approved by the U.S. Immigration Services. However, if H-1B workers wish to travel abroad during their approval period, they must also apply for a visa, which is granted by the Department of State through a U.S. or embassy consulate while abroad. This visa serves as essentially a travel sticker that is attached to the H-1B worker's passport and allows them to return to the U.S. in H-1B status. Upon their return to the U.S., H-1B workers are inspected at the airport or port of entry by the Customs and Border Protection, also called the CBP. The CBP has the authority to admit any individual in H-1B or H-4 status. And it is important to note that individuals must always have an H-1B visa, which is the travel sticker in the passport, and also be admitted by the CBP on each trip outside the U.S.
So what are the position eligibility requirements? H-1B eligibility depends on the requirements of the offered position. So the question we typically ask employers is, what are the minimum requirements for entry into the position? Now, the job itself must require a bachelor's degree at a minimum to qualify as an H-1B job. We also try to identify any additional experience requirements for the position, as well as any necessary skills, certification, or licensure requirements for the position. Additionally, we need to identify what are the acceptable fields of study or related fields of study for the degree requirement, which must be at the bachelor's or higher level. It's also important that the foreign national must be able to demonstrate that they hold the requisite degree, experience, certification, or skills to meet the minimum job requirements. In crafting the job description and the requirements, it's important for employers to consider, what have our past hiring practices been? Do we have other employees in this position currently? Or what about the predecessor in this position? What qualifications did that individual have at the time they were hired, so as to ensure that there are consistent hiring practices and consistency across the requirements for the position? Notably, when considering H-1B eligibility, the government or the USCIS is not interested in whether an individual, for example, speaks multiple languages or has a stellar personality or any particular business needs of the employer or even hiring challenges that the employer might be experiencing. The H-1B is solely focused on what are the actual minimum requirements of the offered position. And again, that necessitates that the position requires a bachelor's or higher degree in order to perform the duties of the position.
Similarly, after we have established that the offer position will qualify for H-1B status, the second prong of our analysis is to look at what the individual's eligibility requirements are. To meet the minimum requirement, the position must require at least a bachelor's degree, and the individual must have a similarly related bachelor's degree in the same or a similar field of study that's being required by the position. And there is some range to this. For example, if a software developer position might require a bachelor's degree in computer science, information technology, or another technically related degree field. And the individual can meet that requirement by any range to a narrow extent that would meet that job requirement. It is important to note that the individual must have the required degree at the time of filing the H-1B petition. This is important to note because of the timing of the H-1B CAP petition. One of our common scenarios is that we have S1 students who are near the ending of their program, who must be registered for the CAP in March, but may not complete their degree or the required coursework until May, with a formal degree ceremony happening in June. These individuals can potentially be registered in the lottery process. It is only important that at the time that we are filing the H-1B petition, we can show that individual has completed all of the required academic coursework and requirements to be awarded that qualifying degree. It's also worth noting that a U.S. degree is not required. While some individuals are here in the U.S. in F1 student status, it is not required that they have obtained a U.S. bachelor's degree. If they are in the U.S., they must be enrolled in a public or a non-profit institution. Individuals attending for-profit institutions will not be considered to have a qualifying degree for H-1B purposes. The U.S. institution must also be accredited. This will occasionally come up again in the for-profit institution scenario where the degree being awarded is not from a qualifying institution. So that's something to be aware of when you're evaluating the individual's education credentials. It is also worth noting that the degree does not have to be from a U.S. institution. The individual could be qualifying on a degree they obtained outside of the U.S. If that is the case, it will be required to get a formal credential evaluation to ensure that the degree earned outside of the U.S. is equivalent to a U.S. offered bachelor's degree. In this case, all degrees are not equal. Particularly in some countries, it is possible to obtain a bachelor's degree, but only complete 3 years of academic coursework. For H-1B purposes, that would not be considered the equivalent to a traditional 4-year bachelor's degree. So that is something to consider when looking at exactly what type of degree this individual is qualifying on and where that degree was awarded.
So while the H-1B is perhaps the most popular type of work visa, unfortunately, it is subject to an annual quota or cap on the number of available H-1Bs. And this often takes employers by surprise that it's such a popular work visa, but limited to a cap and an entire lottery process. So what is that annual limitation? Well, Congress has set aside an annual limit of 85,000 H-1B visas for each fiscal year. Now, the fiscal year runs from October 1 of the given year to September 30th of that year. Of the total 85,000 available H-1B visas, 65,000 are set aside for individuals with a bachelor's or higher degree. This is often referred to as the general pool of H-1Bs. And then we have a special carve-out of 20,000 H-1B visas for individuals with a master's or higher degree from a U.S. institution of higher education, as defined by the Higher Education Act. This pool of individuals are referred to as the master's cap. And interestingly, this group actually has an advantage in the lottery process, which we'll cover more later. But essentially, they get 2 shots at being selected in the annual lottery.
It is important to note that while most employers are subject to the annual cap limitation, there are some exceptions, specifically for institutions of higher education, institutions that are affiliated with institutions of higher education, and some nonprofit and government research organizations. If you are lucky enough to be counted under one of these cap exemptions, you are not limited to entering your individuals in March and against the lottery process. That H-1B can be filed by cap-exempt employers at any time during the year, which is a significant advantage. It is an interesting note that for-profit employers can take advantage of the cap-exempt status. There is a specific carve-out for concurrent employment between for-profit employers and cap-exempt institutions. This is typically universities, not-for-profit entities, and some government research entities. The regulations allow individual H-1B workers to work for both a cap-exempt institution while also working for a cap-subject institution. And this balance between 2 employers can be as little as 5 to 10 hours per week for the cap-exempt employer, and allowing an additional 30 to 40 hours to be worked for the cap-subject employer. It does require 2 H-1B petitions to be filed, one initially by the cap-exempt employer and a second by the cap-subject employer. The cap-subject employer must maintain both forms of employment for the entire approved period. It's not sufficient that an individual gets an initial approval from, say, a university and then immediately quits to work for a for-profit employer. If an H-1B status holder initially is approved for H-1B status with a cap-exempt employer, they will become subject to the annual cap if they turn around and exclusively work for a cap-subject employer. The benefit in this type of concurrent employment can often be for those F1 students who miss out on their initial cap filing. If an individual is not selected, this might be a good opportunity for them to return to their university or a nonprofit organization and work on a part-time basis while they are able to continue living and working in the U.S. with their initial cap subject employer that they were intending to be sponsored by. So it's something to consider as a possible option for individuals who wish to remain in the U.S. but may not be selected in the initial process. With that, we are coming to today's first secret word, which is exempt. We would ask you to please select exempt from the list of 3 multiple choices on your screen. wait just a few more moments longer to the last attendees check in.
Okay, and moving on with our presentation. So what is the lottery process like for those who are CAP subject employers? It'll be especially important to take note of the timing considerations of the registration process. So notably, in 2020, the government unveiled what we still call the new electronic registration process. It's still fairly new, and we do encounter technical glitches just about every year with the system. However, I must say that overall, it's really been a well-received system. Prior to 2020, March Madness had a whole different meaning for immigration attorneys, and the month of March was just notorious as a very stressful period for immigration practitioners, as we would be scrambling to prepare full-blown H-1B petitions to submit to the USCIS, complete with all filing fees as part of the lottery submission, not knowing until weeks or in some years, months later, which petitions were selected in the lottery. And we would learn of the cases not selected when we would receive the petition back by regular mail, weeks or months later. So you can imagine that long period of uncertainty that lingered for attorneys, for employers, and for the foreign nationals. So this new electronic system has really been a game changer. The way it works is that the government has created this H-1B portal online where employers have to register and create an employer USCIS account for H-1B registration purposes. Notably, the window for creating new accounts this year began just yesterday. However, remember how I mentioned technical glitches? So apparently the system was not functioning the way it was supposed to yesterday, and our immigration listserv and immigration bar was flooded with communications about employers not being able to properly register and create their account. We just got word a short while ago that our immigration bar AILA has liaised with the USCIS, and they have confirmed that they have fixed the issue. So now employers should be able to go forward with creating their account. They do not have to create a new account every year. You just need to create an account. Now, if the contact person at the company changes or the company changes name, then yes, a new account needs to be created again the next year. So aside from the employer account, us as attorneys, we also have an account with the USCIS, and we actually do the data input for each foreign national's registration, along with our G28 attorney appearance information into this H-1B portal. That information is then reviewed by us, and we then electronically transmit it to the employer, and it appears in their account. They will have to review and sign off on all the data as being accurate. It is then bounced back to the employer account, where we submit the $10 registration fee per registration and pay that to the government, and then release the registration into the lottery. And that concludes the electronic handshake process between the employer's account and the attorney account. And then it is released into the lottery. Notably, this year, the registration period will run from March 1st at 12 p.m. noon Eastern Time through March 17th, 12 p.m. Eastern Time. So again, very important dates to take note of. This opportunity only comes up once a year, every March, and the window has a hard start and stop date and time. So March 1 through March 17. Now, The information in the registration is actually rather minimal about the foreign national. We input information like their name, their date of birth, their country of birth, gender, passport number, and whether we're submitting the registration under the general cap or the master's cap. So remember that master's cap is only limited to graduates of U.S. institutions at the master's or higher level. Interestingly, there's actually no information about the job offer, requirements, or details that go into the registration, nor is there any information about how the foreign national qualifies for the job or what degree they hold. That information does not go into the registration. So then all the registrations must conclude by March 17th into the lottery portal online.
Now, although the electronic registration process does not require extensive amounts of information, because of the limited 17-day window each year, we do recommend employers consider identifying the individuals and the jobs they will be filling much earlier before the March 1st start date. The last thing you want to have is a very panicked individual coming into your office on March 15th saying, I need H-1B sponsorship, please get me in the lottery this year. We definitely recommend employers start at the beginning of the year in January or February to know who the employees are that will need or want employer sponsorship and where they are located within your organization. The typical scenario that we see are F1 students who are either nearing the end of their graduate program or are a recent graduate and perhaps working in their first year after graduation. H-1B first-time applicants are not limited to only students. There are many other types of status that could be changing to H-1B. And so it's important for either the HR representative in your organization or your managers that might be employing these individuals to be proactively contacted so that we can identify who those individuals are and have plenty of time to collect their information and their job details before the H-1B registration window opens. Some of the considerations you might want to consider is not only what role that individual is currently holding in your organization, but what will their H-1B role be if they are approved for H-1B status, which would start on October 1st. That is particularly relevant if you are hiring F1 student interns who might be only working on a part-time or full-time basis with your company right now, but there is a professional H-1B qualifying position that you are willing to offer them that will become effective on October 1st. So it's something to consider not just what they're doing right now on their day-to-day, but what they could be doing to qualify for an H-1B role later in the year. Another consideration is not only what the requirements are for the job, but particularly if an individual is working or being moved to a professional role. As I mentioned earlier, there are minimum prevailing wage requirements for all H-1B positions, and that will be based on the education required for the position, how many years of experience are required for the position, and where the work will be physically performed. This has tripped up a lot of employers who are moving to hybrid work sites or allowing strictly from work from home environments where the role might be offered here in St. Louis, but the individual would be allowed to live in a much higher area. Florida and California are very popular options for individuals who are being given that option. But it's something for the employer to be aware of because it will directly impact the minimum prevailing wage that will be required to be paid to that individual for the position.
So why do we have a lottery process? We often get asked this question, and it's because historically the demand for CAP subject H-1B visas has always exceeded the supply. And frankly, it's forecasted to just remain that way, as the H-1B is a very popular work visa. So that's why the government has created this computer-generated lottery selection process. Just to give you some context, last year for fiscal year 2023 H-1B petition filing, the USCIS received over 483,000 H-1B registrations in that online portal. Of those, the government selected 126,000 registrations, or about 26% of those were selected. Roughly, the odds are 1 in 4 of being selected. Now, for some more historical context, the prior year, so we're talking fiscal year 2022, the government received over 300,000 registrations and selected roughly 87,000 of those. From that initial lottery process, the government was actually unable to meet the quota because a sufficient number did not ultimately proceed with an H-1B petition being filed on the merits, or a number of those cases were denied. Therefore, the lottery was not met. So what did the government do? Well, they conducted additional lotteries that year. They had a second lottery in July and yet a third lottery in November. Now, mind you, the government does not give us any sort of heads up that the quota is not met or that they were going to conduct another lottery. So it took us all by surprise, and I'll say a pleasant surprise, that there would be subsequent lottery periods that year. Now, last year, the government actually selected a higher number of registrations, and as a result, there was only one lottery selection. We were hopeful throughout the year that there might be a second or even a third, as there was the year prior, but it did not happen. And we would assume the government is going to do something similar this year and select enough from the first round of conducting the lottery. But that is something that remains available, and until the government puts out an actual statement that they have met the lottery, we do hold on to some hope that there might be a subsequent lottery selection. And our employers and foreign nationals remain hopeful of that as well. Now, as far as the lottery, remember, there's actually 2 lotteries that take place. The first is for those with a U.S. master's or higher degree. Then out of that lottery, those registrations that are not selected go into that general H-1B pool, and then the government conducts the second lottery. So remember, as I mentioned earlier, those with the U.S. master's degree or higher have that slight advantage. That's what I'm talking about. They actually get 2 shots at being selected in this lottery process. So there's certainly an advantage with having a U.S. master's or higher degree. This year, the government has announced that they intend to release the selection results on March 31. So as we get closer to that date and the government makes the selections, they will begin notifying employers and attorneys that an action has been taken and to log into the account. So we will then log in, and we will see each registration is associated with a particular status. It will reflect either submitted, selected, or denied. Now, those that are submitted are the ones that were not selected, and they will stay in this submitted mode until the government actually reaches the quota. Now, those that are selected will also have a selection notice, a PDF document attached to that registration, which will confirm that they were selected. It will identify the foreign national and the employer. Now, in some instances, the portal might reflect denied as a status. For example, this can happen when there are multiple registrations by the same employer for the same foreign national. That's a big no-no. So please be mindful not to register the same individual multiple times. It does not increase their odds of selection. In fact, it will result in an outright denial. All of the registrations associated with the same individual will be denied. So please be mindful and careful when registering foreign nationals. Now, following the selection process, the government will outline the 90-day filing window. Typically, this runs from early April through the end of June. And that's when the employers have to provide the documentation that's requested by the attorneys so that we can prepare the I-129 H-1B petition to file it with the USCIS for an adjudication on the merits. There's a number of documents that go into an H-1B petition, and there's some bullet points there on the slide for you. Importantly, the form I-129, there are several pages to this form, as well as additional data collection forms, and that selection notice from the H-1B portal confirming that that particular individual was selected. There's also a number of government filing fees that have to be included with the H-1B petition. There is a base fee of $460, as well as a fraud fee of $500, and a U.S. worker training fee of $1,500, which is actually just $750 if you have less than 25 full-time employees. There's also an optional premium processing fee of $2,500 that can be paid for a faster adjudication of the petition. It's important to note that all of the government fees must be paid by the employer. They cannot be paid by the employee, with the exception of the optional premium processing fee. Also included with an H-1B petition is a certified LCA or labor condition application, which Melinda touched upon earlier. That serves as the attestation between the U.S. employer and the Department of Labor that they attest to paying the prevailing wage or higher for that occupation based on the sophistication of the position and in the particular geographical location of the actual work site where the job will be performed. It also includes supporting documentation about the job offer, the important document there being the employer support letter, which provides an overview about the company, when it was founded, what the industry is, what sort of services are provided, and then a summary about the actual job, the H-1B position, including bullet points of the key responsibilities. Sometimes we also include percentages of time spent performing those responsibilities, as well as a summary of how the beneficiary qualifies for that position. We also include marketing materials about the company, and sometimes when we're dealing with a smaller company or a new startup, we'll include financial documents to avert any doubt that the company has the financial means to pay the H-1B salary. We also include evidence that the individual meets the job requirements. So important here is copies of the individual's degrees and official transcripts, any foreign degree with translation if needed, along with a foreign degree evaluation equivalency report to confirm that it's the equivalent of at least a U.S. bachelor's degree. We'll also include documents about the individual's underlying immigration status to show that they have lawfully entered the United States and lawfully maintained their status throughout their period of stay up until filing the I-129 petition seeking a change of status. We also include a copy of their passport and their I-94 admission record, which evidences their lawful entry and status and period of authorized stay. Now, once we file the H-1B, there's no guarantee the government's going to approve the petition. Now it's in the hands of an adjudicator at the USCIS. So while we always prepare robust and thorough petitions, there are your tried and tested categories of H-1Bs, for example, accountants and engineers and architects and physicians. And then there are those sort of non-traditional or newer or emerging occupations that sometimes can be challenged by the government. And when the government challenges an H-1B, they issue what's called a request for evidence, and they will outline the deficiency of the petition and afford a period of time to respond. It's typically around a 3-month period. Sort of the more common challenge is as to the specialty occupation nature of the position. In other words, the government is not fully convinced that the position truly requires one to have a bachelor's or higher degree to perform the job. So that has to be responded to in a timely manner, and then it resets the adjudication clock for the government to rule on the petition. And that will bring us to our next secret word. And so today's second secret word is lottery. Please select the correct word below. And we'll give it here just a little bit more time for folks to go ahead and click on the correct secret word. And just a couple more seconds here.
All right, so now we'll assume everything has gone completely according to plan. The applicant was registered in the electronic process, was selected in the lottery, the H-1B petition and all the supporting documents has been submitted and ultimately approved by the USCIS, and now the USCIS has issued the I-797 approval notice, which is the H-1B status for the employee and also lists the validity dates of that H-1B status. For all H-1B first-time employment, it will begin on October 1st. That is the earliest start date a CAP subject H-1B individual can begin employment. Now, this can sometimes create an issue because if you recall, we're doing our registration in March, we're submitting our H-1B petition May to June, but there can often be a gap between getting the approval in hand and actually being able to begin H-1B employment on October 1st. For individuals who are in the U.S. when the H-1B petition is approved, their I-797 notice will come attached with an I-94 record. And as a function of their regulations, they do not need to take any additional steps to change their status. On October 1st, their status will automatically begin and they will be considered an H-1B worker, and that I-797 notice will be the document employers need to update the I-9 records and move forward with employing that individual in H-1B status. That will also be an important date if there needs to be any wage bumps for H-1B status. If the individual is being offered, say, a part-time to full-time position, that minimum prevailing wage will need to begin and be paid to the H-1B worker on October 1st. Due to this timing issue between when H-1B status is submitted and approved and when it actually begins, this can create a potential break in work authorization for some current employees who might already be employed with the sponsoring company. Most current employees will be maintaining some sort of work authorization. The most common type that we deal with are those F1 students who either recently graduated or have graduated within the last year to 2 years. For F1 students, they have a range of potential work options. They are all approved by their school and approved with a Form I-120, which lays out the type of work authorization they have, who they are allowed to work for, whether that work authorization is full or part-time status, and the specific dates of duration for that work authorization. The most common forms that are issued by the school are what's called CPT, which is curricular practical training, OPT, which is optional practical training, and STEM OPT, which is the longest available work authorization for those individuals who graduated in one of the STEM fields from a U.S. institution. The most common issue we see with these employment authorizations issued by the school is that they're often tied to the completion of the degree program. So this is where we run into the issue of an individual who graduated in May or June, and their work authorization is tied to the completion of that program. They have a specific extension that's allowed to them if they are selected in the H-1B lottery. They can qualify for what is called cap gap coverage. And this is, again, work authorization that's specifically issued by the school and specifically designed to cover the summer gap period between being approved for H-1B status and actually being able to start work in H-1B status on October 1st. For any of your current employees who might need to take advantage of cap gap coverage or might need to file an extension of their work authorization to cover this summer period, we always recommend they stay in frequent contact with their school, with their international affairs office, because those Department of State officials will be able to approve and authorize any additional extensions of work authorization needed to cover this period in the H-1B process. Now, the H-1B approval does not necessarily is limited to current employees that are in the U.S. Employers can also file and be approved for H-1B status for individuals who are currently outside of the U.S. The process for those individuals will be the same as far as submitting a petition to the USCIS, but they will have an additional step before they are able to enter the U.S. and obtain H-1B work authorization. So for those individuals outside the U.S., they will also receive an I-797 approval from the USCIS, approving their status to H-1B starting October 1st, but it will be approved for consular processing. That is the extra step that they will need to take. It's actually applying for an H-1B visa sticker in their passport from a U.S. consulate or U.S. embassy outside of the U.S. That process is fairly straightforward. Once the individual receives the I-797 approval, they will need to complete a DS-160, which is an online visa application form with the Department of State. They will have to pay an additional visa fee, also completed online, and then they will be able to schedule the appointment at the actual consulate or embassy. The biggest issue that we see with this process is strictly the timing issue. Depending on where the individual is applying, we are still seeing significant backlogs in the availability of visa appointments for U.S. consulates across the world. And so it might be 30 days, it might be 6 months before these individuals are able to schedule an appointment at the U.S. consulate or embassy. That is always the hardest step. But once the appointment is scheduled, the individual goes into an in-person interview. This is not meant to be a re-adjudication of the H-1B petition, This is really for the U.S. consulate officer to look at the person in front of them and make sure it's the same individual who has been approved for H-1B status. At that interview, the consulate officer will give a same-day decision on the visa appointment, either approving the visa or not approving the visa. If the visa is ultimately approved, the consulate officer will keep the passport to physically attach the visa, and then the passport is returned to the individual, usually within 5 to 7 business days. One of the advantages of applying through the U.S. consulate, as I mentioned earlier, any spouses or minor children are eligible for H-4 status, and they are able to attend the interview with the principal H-1B applicant in the same interview and also be approved for H-4 visas at that same time. Once everyone's visas are approved and the passports are returned, that H-1B employee and any dependent family members can enter the U.S. up to 10 days prior to October 1st to begin that H-1B employment. It is important to note that that 10-day period does not include work authorization, so they will be subject to the same limitations as an individual who remained in the U.S. October 1st is the first day they can begin H-1B employment authorization. One additional consideration over this summer period is international travel plans. Again, a lot of the individuals we work with are transitioning out of being F1 students to full-time employees, and so they are really excited about going home or doing fabulous international travel before they come back and start that full-time H-1B employment. We will generally caution people to avoid international travel for this period. In addition to general COVID restrictions and COVID delays, there are some inherent risks to international travel that could delay their ability to actually return to the U.S. to timely start that H-1B employment on October 1st. Some additional long-term considerations after October 1st are what the employer and the employee need to do to maintain H-1B standing with the USCIS. H-1B status is employer and worksite specific. As we mentioned, the employer is attesting that the individual will be hired in a specific role to do specific job duties at a specific location, and for those services, they will be paid at least the minimum prevailing wage that the Department of Labor set for that position. And again, that minimum wage is determined by the position requirements, what type of position they will be holding, and where the work is physically going to be performed. And again, this is where we really caution employees, if you have a hybrid or fully remote work policy, it very much matters where you will be allowing these individuals to work moving forward. After an H-1B petition is filed, if there are any substantive changes to the work site or the job, this could be a promotion, this could be a change in the full-time to part-time status, it could be an actual work site move, including any additional remote policy changes. That may require an additional filing to be made with the USCIS, and that filing would have to be made prior to any substantial change taking effect. So after an H-1B petition is approved, whether in a year or 2 years, you as the employer see a significant change in that position, we really encourage you to reach out to an immigration attorney to discuss what, if any, steps are going to be needed to ensure both the individual and the employer stay in good standing with the immigration status.
And just tagging along there, we can't stress enough the importance of communication. We don't want to know 6 months after a promotion has happened. We need to be in conversation prior to any change taking place. So with that, it brings us to the conclusion of our program here, and we want to leave it on a positive note. Look, not everyone is going to get selected in this lottery. It's a lottery after all. We do recommend you try early, you try every year that it's possible, and, accept the fact that, your candidate may not be selected. That does not mean it's the end of the world. The good news is that there are oftentimes alternative options that are available. Now, they may not be the most ideal option, but there are alternatives out there to help maintain lawful status and, in certain circumstances, ongoing work authorization as well for the foreign national. So we're not going to go in depth into all of these alternative options. That could be a whole separate webinar, but we do want to leave the slide open for you to preview what some of these options and considerations might be. There's a whole alphabet soup of visa categories that are available outside of the employment context. There may also be a family-based option that could be available to the foreign national. For example, that individual might be in a long-term committed relationship with a U.S. citizen, and if they get married, there might be a pathway there to apply directly for permanent residency based on marriage to a U.S. citizen. There might be other options available too. Just one of the ones I wanted to highlight was related to continuing an F1 status at the same or higher degree level. There are some lesser-known universities that offer F1 admission in a master's degree program that comes with immediate full-time CPT work authorization. And that often serves as a good way to maintain ongoing employment without any interruption. And a lot of these programs are set up for attending these lesser-known universities remotely while continuing to work for your employer. And you may want to just glance over some of those other options listed out there. We did want to save some time for questions that have been coming into the chat box. And thank you for all of the questions. We do see a large number of questions coming in, so we'll try to tackle a few of these before we wrap up here at the hour. So one of the questions here has to do with what happens to family members of someone who is selected and approved for H-1B change of status stateside. So assuming that the individual was selected, at the time of filing the H-1B, it's important to communicate whether one has dependents in the U.S. so that the proper application to change dependent status is also included with the H-1B. That's called an I-539 application. It's submitted with the H-1B. It may not be approved at the same time as the H-1B, but when it is ultimately approved, then for those dependents, by operation of law, their status too will change to that of H-4, and the approval notice will come with a detachable I-94 admission record confirming their change of status and the validity of that new status. Looks like we have a couple more questions here. Melinda, do you want to take on the next one?
Yes, we received some questions related to the expiration of H-1B status. So in general, H-1B status is available for a period of 6 years, and that does attach to the individual rather than a specific employer. So if an H-1B worker is changing employees very frequently, they will not renew a new 6-year period of H-1B status with each new employer. H-1B status is intended to be a temporary work authorization, so individuals have a number of options at the conclusion of the 6-year period based on what they want to do. Some employees intend to exhaust the 6-year period and then return to a higher level education program, maybe go back and complete their master's degree, and that would involve changing status back to an F1 student status. Some individuals intend to return to their home country, either to accept a new position or transfer to an international office. One of the more popular options for individuals who wish to remain in the U.S. beyond the 6 years is applying for a green card option, and that would be permanent residence to remain in the U.S. as a lawful permanent resident. There are many different paths to obtaining a green card. For our purposes, the most popular one that we work with is employment-sponsored green cards. That is a lengthy process, so if that's something employers see as a future for a employee that they want to have permanently on their staff, we do recommend starting with at least 2 years of H-1B status remaining. So at the end of year 4 would be when we would expect employers who are interested in that option to really start the green card process.
Okay, great. And unfortunately, we're not going to be able to get to the rest of the questions here as we have run upon the hour, but we just wanted to leave this last slide up here that has some helpful resources that you'll want to take note of, and maybe click on those links to just get a better understanding about the registration deadlines we talked about earlier, instructions on how to register an employer account, a link to the actual H-1B regulations, and the Department of Labor prevailing wage site. And also there at the bottom are our email addresses. Please feel free to reach out to us so that we can address any questions that we were not able to tackle during this hour. And we want to thank you for joining us today. And Melinda, if you want to close out the program.
Yes, we'd like to thank you for participating in the webinar today, and we ask that you complete and submit the survey that will display at the conclusion of the webinar. And again, I would just reiterate, if you have any questions, please feel free to reach out to us, and we'll do everything we can to assist.
All right, thank you, everybody.